Good morning. Today we are going to discuss the topic who cannot be sued. Means you can't file a case against these people. In the previous lecture we have seen who cannot file a case, who can't sue. So a person cannot sue, that is a disability. But when we say that you can't file a case against that person, for that person it is a immunity, it is a privilege. You can say he is a lucky guy then, because he can do certain wrongs against you and you are not allowed to file a case against him. Therefore it is a immunity, a personal immunity, a personal privilege for him, and it is a disability for you because you can't file a case against him. In the previous lecture we have seen that previously these people were not allowed, but now they are allowed to file a case. Similarly, in this lecture also we are going to see that you can't file a case against these persons, but we have created certain things by which they can be made liable. Means their liability may not be immediate, their immunity cannot be absolute. They may be liable in other ways. For some cases they may not be liable. For the others they are liable, because the law is going to punish them. Law is going to make them liable. You never go unredressed in law. That is the principle of law. So now we are going to see against whom you can't file a case. The first is the sovereign. The sovereign means the president and the governor. The president and the governor, if they do certain acts in their official capacity, you are not allowed to file a case against them. But if they are doing some wrong in their personal capacity, they are liable. Means they are liable in certain circumstances. The second is the foreign sovereign. As you are making liable your president, your governor in certain cases, for foreign sovereign also it is allowed that you can file a case against them, but only after taking permission of the central government under section 86 of CPC. Means here the topic is you can't sue. They can't be sued, isn't it? They can't be sued, but you can sue them. They are liable. Like a president is liable for the personal wrongs, for the wrongs which he does in the personal capacity. Similarly, a foreign sovereign can be made liable for certain wrongs which he does. But before filing a case, you have to take a permission of the central government under section 86 of CPC. Means they are liable. The third is the ambassador. The ambassadors are the persons who represent their country. So what law says that they are living here, the staff members in the embassy and all, they are exempted only from the local jurisdiction. If an ambassador does any tort, does any wrong, he may not be liable under our law, under our courts, but we will make him liable in his country. Means what our government will do, will collect all evidence, will collect everything against him and complain to his government. His government will take action against the ambassador. Therefore this is not a complete immunity. Here there is only an exemption from local jurisdiction. Our courts cannot make him liable, but his court will make him liable. Therefore ambassadors are also liable, but not under our law, not under our courts, but his court. The next is the public officials, public servants. The public officials, when they are doing some wrong in their official capacity, they are not liable. For personal wrongs they are liable, but when being an officer he does certain things under his official capacity, he is not liable, but for it vicariously his government is liable. Means the basic objective of law is that you will get compensation not from the public official but from the government. The next is infants, that is a minor. Minority is a good defense in contract, in criminal law, but it is not a defense in tort. In torts, they are liable. Means if a minor does some assault, if a minor does some tort where mental element is not required, you can make the minor liable. From his property, you can take compensation. But for those torts which requires mental element, which requires malice and all, for that the minor is not liable, because minority is such an age where the mental capacity is not there. So for torts which require mental capacity like defamation, malicious prosecution, for that the minor will not be liable. But for other torts, the minor will be liable. Same is the condition of a drunkard and a lunatic. A lunatic and a drunkard are liable in tort. But where mental element becomes essential, that is for again malicious prosecution or defamation, the lunatic and the drunkard are liable. Therefore, the position in law for lunatic, drunkard and infant is same. They all are liable. But these people are differently treated in criminal law. Next is the trade union. Whether you can make liable a trade union. Yes, you can make liable a trade union. Today, trade unions are a body corporate. They can be sued. A married woman, yes, you can make liable a married woman, because today she is a separate entity. In the previous lecture, I told you, in England, not in India, in England, after marriage, the husband and the wife, they were considered to be one entity. Therefore, if a woman does some tort, the third person, means the victim of the tort, had to file a case against the wife, and also he has to make her husband as a party. Making party the husband was essential. But now this one entity concept, husband wife are considered to be one entity, this concept is being removed. This is not there in England. In India it was not there from previous time only. Therefore, a case can be filed against a married woman. Her husband will not be liable for that. They both are now a separate entity. Now, a corporation, that is a company. I told you, a company is like a human being. A company can sue, be sued. Company can enter into contract. Company is having a name. Everything like a human being it has. Only the company does not have the flesh and the blood. Everything other things are there with the company. Therefore, we can file a case against the company. Company can be made liable if, again if is there, if the directors or the officers of the company are acting within the scope of their authority. Three main points are there which we have to see before making the company liable. The first is the officer should act within the scope of the authority. He has to act for the purpose of the corporation, and he should be authorized by the articles. There are two important documents for a company. One is the Memorandum of Association, the other is the Article of Association. Therefore, whatever he is doing, that should be authorized by the articles. It should be done for the purpose of the company, that is a corporation, and he should be acting within the scope of the authority. To understand this, we will take one case. The name of the case is Polton versus Londa and SW Railway Company. Now, the railway company is having its own memorandum and articles and all, and in that what is mentioned, that if anybody is in the railways without a ticket, then he can be arrested. Clearly it is mentioned, if some passenger is there without the ticket, then the officers of the company can arrest. So, powers of arrest are given to the officers. Now, in this case, what happens? Polton has taken his own ticket, but he is taking a horse with him in the railways, but he has not taken the ticket of the horse. He has not paid the charges for taking the horse from the railways. It means what has happened? He has taken his own ticket, but he has not taken or paid the charges for the horse. Fare of the horse is not paid. So what the station master does? The station master sees he is asking for the ticket. Polton shows his own ticket, but he is not able to show the fare of the charges or the ticket of the horse because he has not paid. So what the station master does? He is arresting Polton. Therefore, Polton has filed a case against the company, against the corporation. Now we have to see here whether it is within the scope of authority, whether it is for the purpose of corporation, whether it is authorized by the article. So in this case, the article was authorizing the station master to arrest a person if his own ticket was not taken. But here Polton has taken his own ticket, and the station master has arrested Polton. Therefore, the station master has done an unauthorized act, an act which is outside the scope of his authority. Therefore, the station master, he himself personally will be liable and not the company, because he has done some unauthorized act. What the station master should have done? He should have asked the ticket of Polton. Polton has showed the ticket. He should have asked for the fare of the horse. The fare of the horse is not paid by Polton. So what the station master should have done? Station master should have kept the horse with him, and he should have told Polton, pay the fine, pay the charges and take the horse. If Polton would have done this, he would have been within the scope, within the authority, and he would have acted for the purpose of the corporation. Is it understood the case? So if you want to make a corporation liable, if you want to make the company liable, first we have to see whether it is within the scope of the authority of the company. If the company is authorized to do something, then its officers, if they are doing certain acts within the scope, within the authority, then for their wrongs, for their torts, vicariously the company can be liable. Today we have seen those persons who cannot be sued, but we have also at the same time seen that they can be sued. Law will catch them. Understood? Okay. Bye bye. See you in the next lecture.